right, well, hello everyone, and thank you for joining us for today's Legal Value Network webinar, Leveraging Pricing, Technology, and Project Management to Retain Talent and Drive Growth. I am Colleen Miglio, Program Manager for LVN. Before we get started, I would like to go through a few housekeeping notes. Today's session is being recorded. We are using Zoom webinar, therefore attendees will be muted. We encourage you to use both the chat and the Q&A features found on your Zoom controls throughout the session. Now I'd like to introduce Brad Blickstein, Principal at Blickstein Group and Partner and Co-Head of NewLaw at B&B. Brad?
Thanks, Colleen. Appreciate that. And welcome everybody to Leveraging Pricing Technology and Project Management to Retain Talent and Drive Growth. Before we get started, I would like to introduce our co-panelists. We have from Perkins Coie, Kristina Lambright, from Intapp, Devin O'Leary, and also Kate Boyd from Validity Finance. Welcome everybody and welcome to all our attendees today. The reason for this roundtable for this webinar is we are in a situation right now, I think we all know, that is a bit of a war for talent. We are losing good people all the time. And there are some strategies and tactics that have been undertaken by legal pricing and project management professionals to help retain both talent and clients. And we're going to talk about that today. That's what today's overall webinar topic is. The session is underpinned by data from the Legal Pricing and Project Management Survey. This survey is undertaken each year. It's a combined project from Blickstein Group and the Legal Value Network in collaboration with Intapp. And we look at demographics, challenges that professionals face, metrics they use, opinions on dozens of different issues. All kinds of issues related to legal pricing and project management professionals at law firms are being studied. What really makes the survey different and interesting is that it's a counterpart to the annual law department operations survey that Blickstein Group has been doing for 14 years. And we ask a lot of the same questions or questions in counterpart and get the opinion or the take from both the law firm pricing project management people and their counterpart within the law department, who has sort of the same similar job function, but from the other side of the aisle. So there's all kinds of good information like that in the survey. Please go ahead and download it. You can download it from the Blickstein Group website or from the LVN website. And that's going to underpin a lot of what we talk about today. So let's, before we go too far, I do want to thank the advisory board for our survey, and also thank our sponsors for both the survey and the webinar, Intapp and Validity, and also our friends at LexFusion. So let's get started. We're divided today's agenda really into 4 big areas. We're going to talk about pricing models. We're going to talk about tech. We're going to talk about processes. We're going to talk about obtaining the resources for doing any and all of this cool stuff we're talking about. And then we'll ask everybody to sort of provide a final tip. As Colleen mentioned, we've left some time at the end for questions, but we'll take them at any time. So please enter any questions you have into the Q&A module. If we can answer them along the way, we will. If we can't answer them along the way, we've saved a few moments at the end. So let's get started. I want to start with this piece of data here. We ask in the LPPM survey, other than rival law firms, what do you view as the chief rival to your firm's ability to source and maintain business today? What you're seeing here is a huge reaction to the war on talent. 28% said this year that they expect their chief rival is losing clients through lateral hires. That's a big number and much bigger than the 13% that we saw last year. However, it may or may not be a permanent thing. Only 19% said that they believe that'll still be the issue in 5 years. That'll still be their chief rivals. So just to kick us off, Kristina, let's start with you. Like, what does all this mean to you?
Sure, Brad. I'm happy to be here and chatting about this topic in particular. The numbers that you've thrown up here on the screen aren't surprising. If you read NewLaw, any of the articles that are out there, I mean, the talent war is real. I think firms at all levels are feeling it. So the numbers don't surprise me. The challenges, I think, internally on the firm side, at least I can speak from my perspective, is understanding, where we're losing folks or where folks, and then where folks are going. What's attracting folks to the platform that they're moving to? And then how can we do better? If it's a tech issue, if it's a client support issue, if it's a staffing issue, it's a time, I think, for firms to look internally from a retention standpoint and sort of understand, if we're losing folks in this particular practice, what deficiencies there? Is it technology? Is there some sort of management issue with respect to who's managing the group? So there's all sorts of things from a management standpoint that you can dig into. But I think one critical piece that is, I think, part of the tie-in here to the survey is the client service piece. So understanding if the clients are happy with the talent that we have staffing it and the relationship they have, not only with the firm, but with the client lead or the client relationship partner. A lot of times we've seen when we've had laterals leave and take their books of business, because when you hire talent, you're essentially hiring their business unit or their book. You want to understand what sort of connections they have to the firm. If there's cross-selling and they're doing that within the firm, that's a little stickier. So understanding the relationship that's there with that client is part of that retention audit, if you will, and understanding, where there's disruption, where there's challenges, and addressing those at their core. But these numbers don't surprise me. I do agree with the 5 years, we'll see it taper off a bit, but there's still a big delta between this year and last year. So I think that will continue as more firms go out and try to pull in talent that helps support the needs they have, not only with their clients, but just in broadening their service delivery opportunity and platform on a national level.
Kate, what do these numbers mean to you?
So the piece that I jump in on, and I found when I first looked at these, I'm constantly toggling between the slide before and this, which I would encourage attendees to also look and do, is, I think we are right now definitely in war for talent. I think we're all feeling that. But I think looking at, like the maroon automation and technology, and the in-house and the big four, and how much people are anticipating those changing as we flip forward to the 5-year threat, really speaks to me about, we need to stop the bleeding now, but we also need to be investing, and firms need to be investing in a long-term thinking about how this competitive environment is going to be shifting, and what are some of the things that can be done to really protect about those with, the team that you have in place to support your retention programs, the technology that you're using, and also the financial strength of the firms to make sure that you're being able to invest year on year.
Hey, Devin, you live and breathe automation and technology quite a bit, and we're seeing some big numbers here, right? Like currently only 3% see that as the rival to their firm's ability to source and maintain business. Next, in 5 years, they think that number is going to jump. 28% think that that's going to be their chief rival. What do you make of that? I mean, what do where is that really a big rival, and what can firms and law departments do about that? What should they do about that?
Yeah, fair enough. I think it's incredibly important to think about that, and I think to me, it's not surprising that automation and technology is kind of getting higher in 5 years. I mean, the arc of tech at this moment is changing. We're able to use technologies now to develop things more quickly. We're able to leverage large data sets with artificial intelligence to really create a new perspective on the way people are going to market. And I think, in the grand scheme of things, when you think about the differences between a firm and a law department, they are kind of in this constant movement of, hey, we need more information, we need more transparency, and the firm's trying to provide more. And then, that kind of pushes back and forth. And I think what ends up happening as you start to cycle through this is, if you have, and I like what Kate said about, you have to have an arc of how this is going to go. How are you going to continue to prepare your teams and your firm and your technology to absorb what is coming in the future? And I think that has to be diligent. You got to start somewhere. Oftentimes we'll have firms kind of think about, well, listen, I want to apply artificial intelligence to this issue. And, you think about it and it's like, yeah, that's good, but you got to start and then you have to have a plan. And I think that's what's actually showing here is that firms and law departments realize that over the next 5 years, there has to be a plan to increase against this automation and technology as kind of being adopted by competitors or otherwise. The other piece that always kind of hits my lens here is when you start to think about, well, why would these different lateral hire groups move? And for some reason, there has to be a higher level of success with where they're going. They wouldn't necessarily leave if that wasn't the case. And I think Kristina mentioned it. It is going to be things like technology. It is going to be things like the support of the firm that are going to provide a landscape that seems to be more accretive in value for them. So I think all of that, of course, from my perspective, is going to be leveraged from one side or the other by technology. But really, the two together are kind of the most interesting to me, I think, because one is driving the other. And it'd almost be kind of interesting to see how it would look at 3 years, right? If it was a direct straight line, it'd be kind of funny. But I think even at 3 years, there's going to be some changes to these numbers.
And one thing I wonder about is, one of the big issues I wonder about is who is going to be applying that automation technology, right? Like, you could almost split that into 3 or 4 groups, some of which are already like on the graph, right? Like, what of that automation technology is going to be run by the law department? What of it is going to be run by traditional ALSPs or the big four? They're both making a big push into, hey, we're good at technology, we're good at process, just let us do it for you. Like, there's no reason, Mr. General Counsel, to go buy a system, just, let us do it. We already have those systems in place. And then, I think we're going to see a bigger chunk of self-service legal as well, where we're seeing clients themselves, both internal and external, use technology themselves, sort of with some, set of an expert system or something set up by the law department, but actually used day to day by the clients themselves in a way to scale the expertise from the law department. So
yeah, I see that too, Brad. You know what? I mean, I think, then once you start to have the different groups adding multiple types of technology, it's about keeping the data in sync and shareable and communicable. You're going to want to be able to find processes to share that information, which is always one of those things that drives more tech in the sense of integration and otherwise. So I think you're exactly right about that. There is this coming moment where, we're going to have to converge multiple perspectives of technology from the individual departments that are listed around this graph.
Yeah. And, moving us on for a minute, a bit of a segue. One of the biggest issues here, almost bigger in my mind than the building and the deployment of technology, is the pricing model around that, right? If a law firm builds a self-service model that its clients use, it's not fair to say there's no value in that. The client should be paying for that, but you can't just bill them hourly for what? For nothing, for going and pulling down their own information from your expert system. So we do need to start thinking about new pricing models as we are building some of these things. And in that direction, alternative fee arrangements are one of those areas, or really all of this is around what alternative fee arrangements make sense. According to our survey, we've seen all kinds of different AFAs being tried by different law departments, by different companies. Some of them, what I like to call, are value-based, sort of fixed fee, where you pay or get paid based upon the value you received. Some are, really still time-based, but they're either packaged together differently, or maybe they shift the risk of overages from the client to the firm. Still real valuable, but there's a number of different ways to skin the cat. So, so again, Kristina, like, you deal with this stuff all the time. Like, what does this mean? What is the impact of AFAs on retaining talent, on retaining clients?
I think it plays a big role, Brad, in terms of stickiness for the client. If you've got a pretty high level or complex AFA that your firm is helping to manage, not only through the relationship partner, but you have, that project management piece, budget management piece in place, it's going to be a little more difficult to transition that particular client or work. And the client, I think, would be a little more hesitant to pull that away unless there's a clear path at the new platform, that it's going to be seamless integration. They're going to have the same level of support. So there's a bit of risk there when you do have that in place. It also depends on, it's good to look at what sort of maturity sort of stage you're in with an AFA. If it's something you've developed recently, I would say, it may be easier to pull at that point. But if it's something that's been embedded and managed in the firm for years, that's going to be more of a challenge. But I think these are ways and levers that we can pull in terms of trying to hook a client or ensure that client relationship will be sustainable, and because it deepens the relationship. Once you partner with a client and have a clear understanding of what the goals are and what the deliverables are, they likely don't want to have the same conversation with another firm unless someone's pulling their entire group, which I've seen. And so they're familiar with the group that goes to the platform. It's sort of a plug and play, although it never works out that way typically. That maybe is the exception, but not the rule. So I've seen all sorts of options here. It both basically comes down to the client and what their preference is, what's appropriate for the arrangement, and what they prefer to manage on their end. I mean, that's a lot of what drives these decisions.
I can't help to jump in and speak to the two so I got into litigation funding about 4 years ago, and the two that are on this side, the success fee and the contingency fee, are really being underutilized. I think law firms are really tackling, and the LPM teams are really tackling what I would say is the left side column here. But clients and the client retention story, when you talk about success fees and contingency fees, is very sticky. And it's a very different conversation, and it's not easy and it's complicated, but it also is very compelling and does make it harder for clients to move and for the partners that are handling cases to move, because it does lock them in beyond that 1 year horizon. It's really locking them in for the duration of the case. So I hate to think it's something that traps people, but it also is something that gives people that long-term incentive to stick around in ways that, equity may not be doing, or some of these other fixed fee may not be capturing that imagination in the same way.
Yeah, that's interesting. I like that. It's almost, I always think of AFAs as kind of a means of getting to equilibrium, right? The clients sometimes want more predictability. Or in the case of what you were talking about, Kate, a success fee, maybe early on they want to invest a little bit less, but later they'll have a deferred success fee, because ultimately they're looking for an outcome, right? And equilibrium is never just right in the middle. It's some sort of balanced approach to how you're going to get to an outcome, which I think is interesting by these. And I tend to think that when you look at this through the lens of maybe even Intapp for that matter, this list will continue to grow, has been growing, and really the complexities around how AFAs are thought about, explored, discussed, are increasing time and time again. And a lot of that really needs some support of what Kristina was saying, which is just what happened in the past? How long has this been around for us? And what do we know? Does it have predictable outcomes for us that we can leverage in other ways? So I think these are a good listing. And I think, almost if you apply the idea of the 1 year, 3 year, 5 year plan, like this list will look totally different in 5 years, but it'll probably have that same theme. How do we get to some sort of equilibrium that both parties are benefited? And then it has some sort of kind of feeling of mutual success. In that environment, really, you can almost assume that attorneys or even laterals in certain circumstances may be interested in who has the most flexibility and the most knowledge of what types of fees have worked best, because within this, ultimately flexibility will entice new clients to come to a firm, hypothetically, if you were to think about it that way. But yeah, I think this is really interesting how this progresses over time.
I think I'm sorry, Brad, I know you're getting ready to jump in. I think you hit the nail on the head, Devin, in terms of, attracting, what differentiates us. And if you've got a pretty robust pricing, LPM, innovation support team, that is a sale. That's a sales point that we make with our laterals, especially if they are coming from firms that haven't invested in that space or should have been investing, but, just don't have the money the financial stability that Kate mentioned. Those are things that we highlight that is not typical from, at every firm. So to the extent that firms have that, that is something they should be building on and continuing to invest in. The tech piece obviously is very critical, but so are people, and to support that staff and help, counsel their attorneys internally to use that appropriately. But pricing is one piece. I think I'm very proud of our pricing team and think that is something that laterals do use often. The one advantage we have in highlighting that in the recruiting part is they know we're there. And so it's not a, hey, surprise, guess what? You have to come to us for approval for things or letting us help you. They see it as a resource and not necessarily as a stick in terms of, you must do this. So they definitely see it as a value add from a firm support standpoint.
Yeah, that makes total sense to me.
So one thing I always think is interesting is that there's a bunch of different objectives that you can achieve with flat fees, but kind of two major ones, right? There is predictability, which we've already talked about quite a bit, but also cost effectiveness and cost efficiency. And I think it's really interesting, partially because if you look at this list, like some of these, it's very, very hard to build a program that does both, right? If you're focusing on cost predictability, fixed fee, for example, fixed fee per matter, that doesn't necessarily mean that it's going to cost less. In fact, when you factor in the fact that your law firm is taking all the risk of overages, it should cost more across the board or on average, right? But what you're paying for is the predictability that it's going to cost X no matter what. So we ask a question, and I'm curious to hear your take on this, Kate. We asked, do you believe that work done under AFAs is more cost efficient than work done hourly? And for both the law firm folks, the LPPMs, legal pricing and project managers, and for the LDOs, the in-house law department operation professionals, in both cases, roughly 2/3 say that they are, but that also means that roughly 1/3 say that they are not, that AFAs are less cost effective than work that's done hourly. Kate, what's this say to you?
So I really, Kristina and Devin, I think have the lead on this, looking at data and what they're doing. What I see ongoing, and part of the reason why I've been so excited to do the kind of work we're doing, is that lack of predictability. That 36%, I feel like probably is a lot of big, expensive litigation where you just don't know. There's so many different outcomes, and you can branch it and you can model it and you can have your budgets. And I know there's some amazing tools that are out there to help kind of plan that predictability, but a budget can go crazy, and you can wind up getting stuck, which is, I think, part of the challenge and part of the fear and risk that firms are facing and that clients are facing when they're looking at some of those really big, long projects. I think there's enormous opportunity in the others, which is really where I think Kristina and Devin, again, have been living that and breathing that and really making a difference.
I put in my position on this has changed the more we've thought about this and talked about it, just from kind of when it was published in the survey. But I think it's almost one of those things that can change quite a bit when you look at both sides of it. So if we think back to the last slide, the majority of the alternative fees that are listed, and this is oftentimes the case, provide some sort of fix on it, right? Whole left side is fixed fees. There's discounts with bonus, there's caps, there's collar arrangements, there's caps and collars, there's things that put barriers around what the matter will be. And to Kate's point, that gives you some sort of predictability, which feels efficient. But if you fall outside of, like, if you still need the outcome to be what you originally set out to do within that matter. So even if it goes past that fix at some level, at least there's some predictability to the expectation of that. If we have to go to trial, if we have to go to appeal, like, those are events that can happen outside of that. So to me, this is interesting because I think I think it plays into this concept of transparency and expectations. And I think in certain circumstances, if there's a high level of communication and transparency, then maybe hourly could in fact feel as comfortable as alternative fees. But I think what alternative fees do well is they really start to bring that baseline into place, which hourly just can get out of, can be tracked less and can get out of hand, like Kate was saying. So I think there's always this drive to create these fee arrangements for the purposes of having a communication path that is really prescriptive, that is beneficial. I've probably mentioned it before on some of these, there's always this concept of hourly that's going to be in place because you need a measure that can manage this. But alternative fee arrangements are a good apparatus to start with and promote lots of things. And I really think that, the promotion of legal project management is within these alternative fees as well. And the two of them together can really provide a great outcome and great guidance along the way.
So you mentioned real quick, Kristina, you mentioned the hourly element here. So I just want to get this data out there for us to talk about. We asked a question about shadow billing, and we asked if shadow billing is an effective way to measure the value of fixed fees. And most legal pricing and project managers disagree. Most believe that shadow billing is not an effective way to measure the value. Meanwhile, on the law department side, and frankly, this is always a frustration for me, because unlike if you make a flat fee, you should live with it. You shouldn't, or live with it unless it's clearly out of hand. You shouldn't granularly manage a flat fee if you're on the client side. But nevertheless, 50% or so believe that that shadow billing is an effective way to measure the value of fixed fees. So, Kristina, sorry to cut you off, but I wanted to get all our data on the topic out there. But what do you got in mind?
Yeah, no worries. Just going to make a couple of points on the last slide. And I think, Kate and Devin covered a little bit of this. I think it depends on practice area. So I think if you were to cut this out in certain practice areas, you might see different, sort of answers from do we think it works well? So in IP, there's a number of, just flat fee schedules for a lot of what you do in IP. I think to Kate's point, and I'm just making assumptions here, some of the litigation but those parts are a little more unpredictable. And so I think you need to differentiate between certainty and predictability, right? Certainty is one thing. We all know the cost of this. It's on us from a firm standpoint to drive efficiency and drive from a cost perspective down on our side. On the litigation side, it all comes down to the scoping exercise. If you're good at doing it, if your lawyers are good, if your clients are willing to do it, then I think these percentages would flux depending on that sophistication level of scoping. But in certain areas, I agree, litigation. I'm assuming that's where you see a lot of this. But I'm hoping that more clients and firms take the risk of doing more of the AFAs, like Kate mentioned, on the success fee side. It's risky. It's harder to manage to some extent. But it is more interesting from a results-based standpoint and sort of leveraging those. So that's the point I'll make about that slide. On the hourly side, just someone who's been a pricing professional for some time, it's frustrating for me when you spend a lot of time negotiating a flat rate, especially on a larger portfolio, and they want to see your time. I understand it for a couple of reasons. One is we need to understand, we need to measure, right? How are we doing? What sort of effort are we putting in? Where should we be managing better, right? So hourly, time entry can tell us that, and we can work on the management piece. The other thing is the staffing. How are we staffing this? What's your leverage? That should really be more of a firm issue, to be honest, but also the clients are interested in that. Not only from saying if you are mentoring and developing your associates, but from a diversity standpoint. So I can understand, just from that, can we see it? You're giving us reports. We want to trust your reports. It's sort of a trust but verify. That's what I see going on here. So I understand where the clients are coming from. Do I also agree that, hey, we've come up with a price. Why do you need to see my bills? I understand both perspectives, but and I agree with the responses. I think that's kind of spot on to how people feel.
So Kristina or anybody, how do you think this impacts in terms of talent and retention? I mean, we talked a little bit earlier about, if you're a firm that's heavy into flat fees, that helps you maybe retain your people, client, your, but if you got to say to one, like, great, we negotiated this great flat fee and you get to work under a flat fee arrangement with your clients, but you also got to keep your time in 6-minute increments because we're sending them shadow bills. That might not be so appealing. So what do you think of that? Is there an impact, do you think, on the, on the associate level attorneys who are excited by fixed fees but don't necessarily get to do them?
If you're asking that question of me.
I think I am. Let's start with you. See if anybody else
Yeah,
has
no
a
worries.
comment.
More on the partner side, on the retaining talent, but from an associate standpoint, I say if you can make their lives easier from a tech standpoint, less billable hour sort of requirement. I think the challenge we're going to face there, Brad, is you're under a fixed fee. How do we look at that when it comes to compensation? If they're expected to bill a certain number of hours, there's a threshold before a bonus kicks in. I think we need to do a little bit of fixing on our side from a comp standpoint and how those are evaluated at evaluation time. Like how is the value proposition that we've offered the client and the results and the driving the growth in that area? How does that relate to the comp piece? So totally agree that if we can make their lives easier, that is a retention tool. That's the part I said, look internally, and can tech make it easier, engagement make it easier, less billable hours. I think most attorneys are driving to that utopia.
Yeah, and I'll weigh in with, what my industry sometimes jokes is that we're running refugee camps for people who hate the billable hour and want to get away from that. And it's for us, it's a recruitment tool. We get to say, yeah, you could be done with that. And if we think about those charts that we started with, where are we going to lose clients and talent? If law firms, are looking at what the big four are doing, they're not going to be having these billable hours be tracked in the same way. I also think it's rethinking the value. We're coming out of this pandemic. People are rethinking what they value. And, Kristina mentions the younger associates. I think those are the ones who are really going to be rattling the chains in ways that a lot of us have been predicting. The billable hour is going to change in people's responses to it, but they're really going to be pushing on this and asking for different ways to define the measure of value that the firm is putting in them. Because, people used to write books billing by the word, and they weren't great books. So we want to think about, how do we start to reward the way publishers do now, right? And think about that in a very different frame.
I think it's a measure of contribution, right, Kate? It's a contribution measurement versus like an hours, and that doesn't equate to hours or your time.
Right.
Yeah, I totally agree with both of you guys on this. I think, when we looked at it and did some research about the application of artificial intelligence to this, and I don't know that this is certain. I mean, certainly, kind of evidence points this direction, but this comes up just in general analysis of data from artificial intelligence anyway, not specifically legal as well. But there is this idea that people gain confidence in your ability to almost state that you've utilized artificial intelligence to review 3, 5, 7 years worth of data. So it kind of changes the conversation, right? Like, I think Kristina was mentioning like the bill side of things, like, why do you want to see my bills? We already talked about what you're going to get out as the outcome. You should be comfortable with that. And then furthermore said the effort level. It's like, you could almost say, listen, the past 5 years, we have done 200 similar types of matters that have all fallen within this range of effort. So you should feel comfortable with this. We're used to the billable hour, but it's almost, this to me is almost saying we got to train, maybe come up with a new way to train our clients or train the conversation to say, here's how we get to this equilibrium of effort. I don't know. That just popped in my head. I could be going off on a tangent. I've been known to do that.
And the difficulty is, and I'll just kind of take the last word here before we move on to talk about technology directly, is I think in how these services are valued. Because law firms, when you look at what makes them profitable, at least under an hourly billing model, the value is very directly tied to the number of hours spent. And right. Most folks in law departments think the same way. They are, a lot of them came from law firms. They were trained at the same schools, right? They conflate value with effort, and there's a couple reasons for that. One, that's kind of what we've always done, but also the opposite is very difficult, right? It's very difficult to figure out what the real value of the work product is. I mean, In a litigation, if you're on the plaintiff side, it's pretty easy, which is why they tend to use contingencies so often. But if you're writing an agreement, or if you're even if you're on litigation side in defense, it's really hard to understand the value. It's really hard to, and it's hard to see the value of one firm versus another firm as well. So that's part of the problem, I think, is both sides viewing value in relation to effort, as opposed to what's much more difficult and figure out what the real value is, which would lead to a more rational price.
Mhm.
I do want to talk a little bit about technology, and I want to start with this. So we ask both sides, again, this is what I talked about when I said sort of counterpart questions. We ask legal, pricing, and project management people at law firms, are you leveraging technology to deliver services more effectively and cost effectively to your clients? And 84% of law firms say that they are leveraging technology to do that. We asked the same question to law department operations professionals. Are your law firms leveraging technology to deliver legal services more cost effectively and effectively to you? And about 50-50. So a 35% difference between what law firms think they're doing and what clients think they are receiving. So, you know, again, let's start with you again, Kristina. What gives here? It doesn't make any sense.
I think it makes perfect sense to me. I see this a lot. So internally for us, we'll have a situation where either a partner says, or, the practice leadership says, we need this tool. We've seen this tool. We think it's a good way to attract clients, to grow our current clients. Let's put this in place. And so from a business case standpoint, no one's talked to the client at that point. We're going off what someone internally has said. We know this is going to work. This is great. I've seen this happen a number of times in the firms that I've been in, and one currently. And so we implement this technology, and then we go to the client and say, we've got this great new technology. We want you to use it. We think it's providing, helping provide, not only more transparency into what we're doing, but reporting, et cetera. And the client says, well, I have no way of digesting this information. I have no way of processing it internally. And it's really not the data points that I'm interested in, or I report on my side. And so we've not had the conversation. We built something that really doesn't align with what they need from a tech standpoint. I think where I see success, and I'll kind of flip side because we're a devil's advocate, is where you're providing more efficiency on the process piece and workflow piece from the client to firm. For instance, conflicts. Conflicts is always a big challenge. It's usually a bottleneck. If we can make that process from reviewing matters, new clients, et cetera, more seamless and more efficient, clients appreciate that piece. But I think from a tech standpoint, you need to understand what your client needs are. It's much like a pricing conversation. You're not going to put out an AFA if you don't know what the business objectives are of the particular client. Same for technology. It should be in partnership with the client. And I'm talking about things that actually touch the client, not things internally that help drive workflow internally from a process standpoint.
Yeah, I totally agree with that. I think what resonated really well is with me is just that expansion of all the different things that go into this, right? It is the workflow, it is the process, it is the pricing, it is the visibility. It's a lot of stuff that goes into this. And I think when you start to break that out into what is the information that's needed, and then what today, and then what's the information that's needed tomorrow, you have to have a strong centralized location to gather data and enact it, like make it actionable, kind of both internally, but for the relationship. So I think I just agree. I think I just agree with what was said. But I think it'll be interesting to see again, kind of how this progresses over time. It should, the more that it starts to align through conversation, like Kristina said, we should see this start to come more into equilibrium, I think. And then if not, that means that the technologists are making mistakes and not keeping up. So I think we need to sort of think about how we stay in the conversation as well, just to make sure that we're supporting kind of the build of that relationship.
I think you touched on a lot of pieces. to your point, Devin, that are seen internally by our attorneys. And so
Mhm.
they see all the technology. It doesn't necessarily touch the client in the way that it's visible to clients. So that may be where you see a little bit of this, where, it's behind the scenes that we're doing this. However, the client's only seeing this component or what may not be critical from their, a management standpoint for their side, or the transparency piece. And I think it is the data, but it also is that legal service delivery piece as well. That's the other tech component. But
Yeah, that's interesting.
Yeah, I think the only piece I'll add to this, and this I've seen in my own experience and what I do, is I could do a ton of things that would help our clients, but if I can make my lawyers more efficient behind the scenes by automating things and making them be able to get their hands on what they need faster, they're gonna be able to do more for more. And the clients themselves may not know that we've done that, in part because some of it's just getting the railroad down so that the trains can keep running.
And the other thing that I'll add, and I think it's really important for folks here from law firms, is communication with your clients. The fact of the matter is, both of these numbers are probably right, in that if so much of the technology, of the innovation, of the things that are built or used within law firms to serve clients was created or conceived to serve a client or two clients or a practice group within the firm, and not all the practice groups within the firm. So if you're at the firm, you might very reasonable say, oh yeah, well, we do this and we do that and we do this, but that's only hitting a small percentage of your firm. So, and meanwhile, from the client, a client might say, well, half our firms are doing some stuff, but half of them we never hear anything from at all. And I think there's part of the issue here. And I think part of the reason, one of the ways that law firms can get more stickiness from their clients, and probably from their people too, is to make sure that they are aware of innovative programs, including technology, that can benefit them. Because I'll tell you, literally, you can see it right here, more often than not, those clients are not aware of those programs.
Mhm.
Well, let's move on and talk about process. And specifically, let's talk about legal project management. I thought this was a really fascinating statistic, because we've talked earlier about AFAs, and we talked a little bit about how they're most often than not, deemed as cost efficient. But when we ask this question of law firm project managers and pricing professionals, when we ask them, do you believe that work done hourly with a budget and solid LPM is more cost efficient than work done under an AFA? Most agree, a slight majority agree that work done, I would say, I kind of would almost describe it as work done carefully, as opposed to work done with the guardrails of an AFA, can even be more efficient. So let's talk about that a minute. I guess, Kristina, do you agree? How do you answer this question? What do you agree or disagree?
I agree. The reason, from a pricing standpoint, you can craft an awesome AFA that's appropriate for that particular engagement. If you let your lawyers attempt to manage that, and I'm talking about something relatively complex, there's a higher risk that it's probably not going to play well. It's not going to do well. The oversight piece is what's, I think, a critical component on these more complex or more, I think, substantial AFAs. On LPM, I think, I'm going back to the scoping and budgeting. You've got folks in the room talking about expectations and your level setting going into that particular engagement. And so you have both a budget, which folks understand there's predictability, not necessarily certainty. Although you put a budget, they're going to look and say, that's the number we're expecting. But there needs to be continual conversation to the extent it's out of scope, there's issues. You need people there pushing your lawyers who are not really great at going back to the client and saying, hey, this is shifting away, or we need to do a little bit more, or we need to adjust something, or we're going to actually come in under budget. That's great news. You should be wanting to share that with client. You don't have that, I see, as much with AFAs without LPM oversight. So, it's defining that there's only so much bandwidth within a law firm to do that. and putting staff and resource in the place that's necessary with a well thought out scope and budget, I think is great. And I agree. I think that work done under hourly with great LPM is more effective than an AFA that may be unsupervised and can get unwieldy.
Yeah, I think that's the interesting part too, that unsupervised alternative fee arrangement. A lot of times we'll have conversations with folks that kind of say it's almost a set it and forget it in their minds. Like, the client knows what to expect. We know what to expect. It's for us to kind of manage the leverage, and attorneys just get to the outcome. They don't, it's not always managed in the leverage standpoint very well, to Kristina's point. I think, solid LPM really kind of gives you that transparency that you need. I mean, as technologists, we want to we push towards the simplest delivery of information that provides enough guidance within context to make decisions thereafter. And one of the challenges that you have when you think about how do you distribute information to attorneys is how do you make it so consumable that it drives a decision and is used time and time again. And I think there is this move to where alternative fee arrangements start to become more easily managed because they are predictable because of historically based information, where they can have less LPM, but they need some sort of management. I don't know, maybe that's a little bit of insight how we think about it. If we can take, a portion of the firm that's, has a historical precedent on how it performs, associate that to alternative fees, and then provide a good, kind of feedback loop through visualizations of how it's proceeding, then maybe that helps limit some of the burden on the LPM team, but it doesn't mean it doesn't need it, right? It still needs some analysis. It still needs some conversation. But to me, this is almost really kind of the constant churn of efficiency between the two. That sort of probably keeps this one pretty close.
And part of me wants to see it, right? What if we did, alternative fee arrangement also with solid LPM, right? Line these up together and you get everything. The AFA has been developed based on all those models. Make sure that that's sticking around. And the other thing, I think there is that element of unpredictability. I think there is that element of how do you value the outcome. We always used to negotiate software development costs with fixed fees. We're only going to pay this, and everybody knew that the last month of that project, everybody was going to hate each other because you were, pushing against what you needed done and what the developers were no longer willing to bill. And you want to avoid that. You want to align the lawyers and their clients. You want that conversation to happen. You want them to know that there was a solid model and that you're going to value the outcome. So that's my 2 cents on it.
Right, I think that's interesting. And one of the ways that I look at this is that under an AFA, or at least under a flat fee arrangement, the value of really good LPM accrues to the firm. In an hourly arrangement, the value of really good LPM accrues mostly to the client. So I think that's an interesting way to look at this as well. Question: Has this caused, or has sort of maybe an innate understanding of this caused anyone to ever try to talk a client or their own partners maybe out of doing alternative fee arrangements? It seems like heavy lift to create an AFA when maybe there's not that much value in doing so if you can manage correctly.
I've certainly seen that happen. I mean, from my perspective, from the group, I've seen that from time to time. Say, hey, listen, there's more agility needed, but we build for both. Frankly, I'd be interested in Kristina or Kate's position.
The answer is yes to both. So and I think it's being able to sit down. Well, one, that you have trust, built and a good rapport with the attorney that you're talking to. But if there is a client asking for an AFA, it's very difficult to shift the mindset of your partner to say, hey, I know they're asking, but this particular arrangement or engagement is really not appropriate. It's not going to help either side. Like, can we get on the phone and understand why they're asking. If it's a blanket ask to all, that's one thing. But if it's a particular situation where they're only going out to a couple folks, they know us, they like us, the experience is the why they've come to us. What are you trying to achieve on your side? If it's better, the predictability piece, we can do that in a number of ways. So I think it comes down to that communication piece and the transparency between the two. Like, I know you're asking for this, but I think it's going to work out better for both of us from a management standpoint, from an output standpoint, and you need sort of sophisticated people, I think, at the table at certain stages. But it could come down to a simplistic. You give them a couple of options. Hey, I know you asked of this. Why don't you put a few options out there? And that opens the door, at least for them to consider, if they're not set in stone that we have to have this particular, because we've been ordered from on high to have this particular AFA. So I've seen it go both ways. To some success, some not successful conversations. But again, it's really education. A lot of what I do as a pricing professional is just educate on both sides, client and partner, and they're always willing to listen. At least the partners are. Considering the time constraints they have, I really appreciate the opportunity to come in and talk to folks about why this sounds good or why the client is asking, but this might actually work better for the situation.
I would just add, the conversations that I get the opportunity to sit in is where we're helping bridge that gap. Kristina's heard it from the client, the partner's feeling the pressure for the hourly, and sometimes we're called in just to help bridge that and be one of that packet of alternatives where you say, maybe we can serve both, we can make everybody happy on this and smooth out some of the tension.
And Devin made a good point earlier about, if you had success in that space or that particular area and saying, look, we've done it this way for a number of engagements, it's worked out well. If you want to share that with the client and let them know, I know you're asking for this, but we've actually had a lot of success, modeling it or doing it this way, pricing it this way. So I think the historical piece, you can definitely leverage that in your conversations.
Yeah, it's almost kind of the empirical support, right? Makes sense.
Got it. Yeah. So I want to move on to our final topic, if that's all right, and discuss resources. 41% of the law firm respondents to our survey said they do not have access to the right technology to do their job. So, Devin, let's start with you on this one, because you're the provider of a lot of this technology. What can firms do to make sure that their lawyers have the right tech?
I think this is interesting. I think it goes back to a couple of other topics that we've had today, where I think this graph might be a little bit different if you broke it down into practice area too, right? There's different practice areas that have a little bit more attachment to some of the technologies that are in place. To me, I think this goes back to there is now technology that is available to us just in a whole that can really start to provide benefit to the entire firm. And I think some of it ends up being just one kind of a willingness for the firm to move into kind of some new ways of doing things. Spreadsheets are really convenient, but at the end of the day, you need a more comprehensive approach to how you're going to service your 5-year plan, right? For leveraging things like artificial intelligence or leveraging key performance metrics in a way that gives you some type of historical perspective. I think kind of the interesting thing that comes out of our discussion today for me is really how do we start to influence that historical kind of that future historical perspective, right? And a lot of that comes through technology, building a platform of centralized data from people, processes, and other places to be able to be utilized in an actual way in the future. And I think that ends up, that is what we try to position ourselves to do is right, take this data, provide a rich interface that's simple enough to increase the actions of people who haven't traditionally been a person of business action. They've been more of a person of law action. Like, how do we surface information to attorneys to empower them to make decisions and process or communicate better with LPM or with the client, is really kind of the way that we look at this. And I think some of this is just really kind of change management for the technology that kind of can really support historical analysis for the purposes of creating, future beneficial matter kind of schematics that give a predictable outcome. And that can be leveraged in value, right? The more predictability, the more understanding you have of the work that you've done, the better you can defend your value in some of these meetings. But I'd like to see this change, to be perfectly open about that.
Yeah, no, I agree. So Kate, I guess sometimes a resource issue is just a resource issue. And I know that's an area that you work in a lot, right? Helping firms that maybe don't have the resources they need at their fingertips on any given day. So how are ways that firms can look to, identify resources to go and get the right technology? And before you answer real quick, I'm just going to warn our panelists. I'm going to ask you each for one final thought as soon as we're done with this. So maybe put your thinking caps on while Kate answers this question.
So I'm going to use this as my two for Brad. I'm going to put my final thoughts into this answer because I think I can pull it off. I look at this and I just see that pyramid of, your people, your tech, and your finances. It's what firms need to be thinking about, right? Their people need to stick around. They need to feel valued. They need their work to feel valued. They need the technology tools. And one of the stressors, I think, is that every year the finances recycle, right? And you've got to be thinking about that long term. You've got to be thinking about that building equity picture. And sometimes that means pushing some of your costs onto a longer term cycle than your cases have, which is some of why I've been so fascinated to get to do what I do with the law firms that we get to do them, is really help them think about growth, not as just what they can afford year on year, but as what they might be able to afford over 5 years. And we can help finance that so that they can commit those resources to a growth plan to help make sure the technology is there so their people feel valued. And they stick around, which is really where the opportunity comes for me. And I'll go ahead and let somebody else jump in with their final thoughts.
Kristina, ladies first.
Yeah, no, great, Brad. I guess my final thought is, tech is sort of the thread through this entire conversation. To the extent that you can leverage tech in your own organization to engage people, where there's never been a time, I think, in history where we've leveraged technology to engage our teams, engage our clients. Those things are going to help with retention from a talent standpoint. So the more that you can, to Kate's point about keeping people happy, most people, I think, are happy when they're engaged and they feel like they are contributing. They feel like they are actually part of the conversation, part of the change, part of the delivery to the client, right? They're making that team what it is. So that engagement piece, I think, is driven a lot by technology. That gives us the opportunity. My firm is almost fully remote. We have a number of people going in. So technology, we will continue to lean on that. The client piece, I think, from a stickiness and retention and sustainability standpoint and a growth standpoint, to Kate's point, it's necessary. You need to keep building. You need to understand what their needs are. So the tech, I can't hammer home on tech enough, but it's got to be the right tech and understanding what that is. But the people and then the clients are the two keys where I think we need to link the tech and think we have opportunities to do that.
Yeah, I think when I think about this, I think also along the lines of tech. It's almost when I've heard some of the different things that we talked about today, it's almost thinking about having these longer term plans for tech as well, to be able to use the right tech, build the right kind of foundation for it to be utilized in the right way in the future. And I think I think sometimes I tend to find myself, becoming a little bit myopic in the sense of, well, that's pricing tech and that's time tech. But I think there is this major component that we've talked about today, which is our ancillary to that, process tech, maybe even funding tech, right? We've got to have a plan that starts to drive itself from the beginning of the process, business development, through to business delivery that is supported by multiple levels of tech. Really, the one way you're going to be able to do that is to also have a data plan for tech. And I think with pricing it is paramount to have a good visualization of what your historical pricing data has looked like and what it can do for you in the future.
Great. And I'll just add, and this is really kind of just to, I think maybe amplify what Devin said a little bit. I think increasingly clients and especially young attorneys are interested in new legal service delivery models. They are not as interested, they are less interested in, I'll do this piece of work right now, send it off to one person, do that piece of work right now. They are interested in delivery models that are changed, that are leveraged by process and technology and data. And I think that the more effort that is put into building new delivery models, the more satisfied both the clients and the young lawyers are going to end up being over time. The other thing I'd like to do today, right now, is if you like what you saw here, if you like what you heard here, if you thought some of the data that you saw was interesting, please go and download the survey report. It's right here. It's big as day on your screen, lppmsurvey.com. It's free download. Please go ahead and download it. I'd like to thank Devin and Kristina and Kate for joining us today. I'd like to thank our friends at LVN for putting everything together for us. And I'd like to thank all our audience members for joining us today. And thank you very much. If you have any questions, further questions, feel free to reach out to any of us anytime. I don't think we put our contact information, but I know for a fact that none of the four of us are hard to find. So please reach out anytime you'd like. Thanks so much and have a great day, everybody.
Thanks,
Thank
Brad.
you, Brad. Thank you, everyone.
Thanks. Bye-bye.